Welcome back, everybody, to our studies in the law of trusts. In this lesson, we're actually going to be doing something of a crossover between the law of trusts and specifically land law, because we're going to be talking about the various formalities for the creation of trusts in land. Because we noted in previous lessons that really, when we think about the creation of a trust, there are obviously various different ways in which trusts exist, the various different types of trusts, and that there are various different formalities required for the creation of a trust. And we also noted from previous lessons that in the creation of trusts, we have to think about the fact that there is a difference between the creation of an ordinary inter vivos trust versus an inter vivos trust which is operational in relation to land, trusts of land, because there are different formalities in place. This lesson is essentially going to talk about what those formalities are. And in doing so, we will just be crossing over really from the areas of the law of trust that we have been studying previously to the areas in which we examine the idea of trust in land in relation to land law, a subject that we've already covered. So this refers to the types of trust to which the property in question is that of some kind of land, on the one hand, so i.e. an estate itself, or potentially an interest in land. You can have proprietary interest in land which can be held on trust as property. So the creation of an express trust that to whose interest is actually in some kind of land requires quite significant conformity with the formality requirements which are set out in section 53 of the Law of Property Act from 1925. This is obviously something that is not required when we talk about trusts in property that isn't land. So section 53 of the Law of Property Act says that subject to the provision hereafter contained with respect to the creation of interests in land by parole, no interest in land can be created or disposed of except by writing signed by the person creating or conveying the same, or by his agent thereunto lawfully authorized in writing, or by will, or by operation of law. A declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust by his will. A disposition of an equitable interest or trust subsisting at the time of the disposition must be in writing signed by the person disposing of the same, or by his agent thereunto lawfully authorized in writing or by will. So, not particularly clear in terms of being able to understand what we're examining here. The Property Act goes on a little bit more and talks about other elements, but we will get into this in more detail here. Fundamentally, then, let's unpack what this means, because it's not particularly clear, as I've just mentioned, and so it's easier just to unpack the meaning without specific reference to the provision itself. So the most important reference that is to be noted here is that of section 53(1)(b), which essentially outlines the main formalities which are required for the creation of a trust which concerns an interest in land. So section 53(1)(b) says that, quote, a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. So it says that it must be in writing, it must be signed by a settler. These are the two requirements that are necessary for the form to satisfy the formalities for the creation of a trust that concerns an interest in land. The first is, of course, this idea that it must be in writing, and the second is that it has to be signed by a settler. When it comes to being in writing, what we mean by this is that essentially it must include all aspects of the trust as well as satisfy the three certainties. We know already that this is the certainty of intention, certainty of subject matter, and certainty of objects. If you want to know more about this particular topic, go and have a look at our lessons looking at the three certainties that we have looked at previously in other videos. It does not need to be written in the form of a deed. This is something that is very important when we think about the creation of trusts over land, the formalities for creation. You might think that it would be required to be written in the form of a deed, but in fact this isn't actually the case. It is not necessarily required to be written in the form of the deed. And while the trust is technically valid at the point of its declaration, and so as therefore not to require necessarily the need for it to be in writing. It can only ever be enforceable when these requirements are met. So, of course, even though technically, in law, de jure, it is valid at the point of its declaration, de facto, it cannot really be said to be valid given the fact that it is not enforceable until the requirements are met for the establishment of the creation of the trust in land. The other point is that it has to be in writing, firstly, and then also signed by the settler. By signed by the settler, this formality requires that this be followed absolutely. There is an absolute requirement here. It cannot be the case, for instance, that it is signed by an agent, for example, who may be representing the settler on their behalf. This is not allowed, essentially, when we talk about creation of trust in land. And so, as a result of which, we have this slight difference and this slight delineation between the formalities for creating a trust, an inter vivos trust that exists not in land, versus those that are created in instances where the property in question is either land or potentially an interest in land.